Hello, I'm Andrew from Seoul Law Group, and we are an English-speaking law firm based in Seoul. In today's video, I'll be talking about what happens to your F6 visa when getting a divorce in Korea. Due to unfortunate circumstances, marriages can come to an end. Divorce itself is difficult enough, but if you're here in Korea on a marriage immigration visa, F6 visa, there are a few other things that you need to be aware of. What is an F6 visa in Korea? An F6 visa is a visa you receive after marrying a Korean citizen. Technically, there are three subcategories. First, the F6-1 visa is a visa you receive when marrying a Korean citizen. Second, the F6-2 visa is granted if you have custody of children born out of the marriage, including de facto marriage with a Korean citizen. 3. The F6-3 visa is granted if you have been married to a Korean citizen, but through no fault of your own, the marriage has ended. This could be due to death, disappearance, or divorce. For F6 visa's original valid period is 1 year and should be renewed every 2 to 3 years thereafter. It's possible to renew from 4 months before the expiration date. What are the requirements to keep your F6 visa? Basically said, to keep your F6-1 visa and stay in Korea, you need to stay married to your Korean spouse. Generally speaking, if you divorce your partner, you will have to leave Korea. However, if you have children or if the end of the marriage was not your fault, then you can apply for the F6-2 and F6-3 visas, which will allow you to stay in Korea after the end of your marriage. If you have come to a difficult decision to apply for a divorce from your Korean partner, there are 3 ways you can proceed with your divorce. Divorce by agreement, divorce by mediation, and divorce by trial. Whichever method you choose to finalize your divorce, it is important to understand what the effects will be for your F6 visa. Divorce without kids. If you do not have kids, you will not be eligible for an F6-2 visa after your divorce. Therefore, after your divorce, you will either lose your visa or you'll be eligible for an F6-3 visa if you can prove that the divorce is no fault of your own through a trial. If you and your partner already divorced through a mutual agreement or through mediation, you can't renew your F6-1 visa anymore. So, you better renew your visa before your divorce is finalized in the court in order to make your stay in Korea as long as possible. If your F6-1 visa passed its expiration date and you're not granted an F6-3 visa, you will either have to leave the country or try to switch your visa to another visa type. If you don't have any other visa to apply for, the final visa you should try is F16 visa, which is a permit to stay in Korea for 6 months to prepare to leave the country after divorce. You can use those 6 months to clean up your rental deposit, get your property division from your ex-spouse, etc. If you can prove that the end of the marriage is not your fault, you'll be eligible for an F6-3 visa. However, to prove that the marriage has ended due to your Korean spouse, you have to go to court and divorce by trial. If your spouse has passed away or disappeared, you could be granted the F6-3 visa as well. Whose fault the divorce is of course very subjective and difficult to prove in court. Therefore, these trials often take quite a long time, and it is strongly recommended that you work together with lawyers to make your case. There are several situations in which you can prove that the end of the marriage is not your fault. Unchasticity of your partner. This does not mean that your partner has committed adultery, but also refers to other forms of unfaithfulness. Maliciously deserted. If your spouse has neglected their obligation to live as a couple and support the household. Mistreatment. If you or your parents have been mistreated by your spouse or his or her parents. The reason for divorce needs to be proven using several official documents to show that the end of the marriage was not your fault. After the ruling is made in your favor, you can apply for the F6-3 visa. Divorce with kids. If you and your Korean partner have underage children together, you can apply for an F6-2 visa if you have custody of the child or have substantial visitation rights. The child has to be born out of your de facto marriage with your Korean spouse, which includes any children born while you were living together before getting married. If you do not receive custody rights or visitation rights, you will lose your visa and will have to leave Korea when your visa expires. In Korea, child custody is awarded to the parent who has been taking care of the child the most. If there is a history of abuse, drinking, debts, etc., which prevent the parent from taking care of the child properly, the custodial rights will go to the other spouse. You do not have to go to court to get custodial rights. This can also be decided on through a divorce by agreement or divorce by mediation. However, As a divorce by agreement does not have the power of execution, you will have to go to court, sue your ex-partner if they do not honor the agreement that was made. If you have received the custodial rights for your children, you can apply for the F62 visa to raise them in Korea. The F62 visa is valid until the children reach adulthood. You can also keep your visa if you do not have custodial rights, but do have substantial visitation rights. Commonly, visitation rights are set at 2 weekends per month by the courts. But this is something that you and your partner can also discuss by yourselves. If immigration deems that your visitation rights are substantial, you're eligible to receive the F62 visa. You can only receive the F62 visa if the children are not yet adults. Once your children reach adulthood, you're eligible to apply for the F2 visa to stay in Korea with your children. The minimum requirements for this visa are that you have stayed in Korea for at least 5 years to raise children, that you have fulfilled your duty as a care provider, and that you speak a sufficient level of Korean. If the level of Korean is not insufficient, you only receive a 1-year visa, which is eligible for an extension if you improve your Korean. In other cases, you will have to renew your F2 visa every 3 years. Well, we hope you found this video very useful. If you have any questions or concerns about your F6 visa and getting a divorce in Korea, let us know in the comment section below, or please feel free to check out our website, seoullawgroup.com. Don't forget to like, subscribe to our channel, and turn on that notification bell for more Korean law videos. Hope to see you next time. Bye-bye.